Hello everyone, this is Sachin Sawant, your UK immigration lawyer. If you are unable to hear or any issues with the live, please let me know. I am currently doing it outside. I am outside. I have come for my daughter's drama dance session and I'm trying to use this time. So currently I will take the comments, questions on the channel. Uh, the first question that I have, anyone coming live can ask their questions. Hello sir, I am here in the UK on a skilled worker visa. I want I want to call my dependent here without me, but my companies. So the question is about the sponsor is under investigation. This will be a very common question in future because Home Office is investigating all these sponsors who have given these care worker visas and whatever frauds have happened. So there will be many licenses. They will be revoked. It will happen. These things will start coming in. So this is what is happening. In your case also, I see that. Uh, your sponsor is under investigation for the care worker visa that has been issued to you. So you are in the UK on the healthcare visa. You want to sponsor your dependent. So your question is, I want to call my dependent here with my company's. So your company, once it is under investigation, they may downgrade it to B rating or something. They may give them any compliance issues. If there is, so I think this is the usual course. If there is a fraud or something, it will be revoked straight away. If there are any compliance issues that they have not met, the company is given a long list of items to be done. The license is downgraded to B. So the situation will be I'll take on both the situations and I'll take the live questions also. Just wait, I'll complete this uh, because many people will be in this situation. Sponsors will lose license. Home Office is investigating all these care worker, care homes, and all of these very strictly now. So this is a relevant question. Let me answer this as much detail as I can give. A company is still ongoing. So company is ongoing. The sponsor license is live, but it is under investigation. Please tell, is there a way to call her? Yeah, you can still sponsor your dependent. The dependent will be is on the relationship with you. Uh, Most probably, I've never seen if a main applicant files for a visa and the company is under investigation, they may keep it on hold. But in your case, it's a family member, so I don't think they will keep it on hold. 90% chances they will consider and go forward with the application and make a decision on it for your partner wife because it's doesn't have to do much with the sponsor. You are the one who is connected to the sponsor. So I think 90% chances they will make a decision on that, and I don't think that should be an issue. 10% they may keep it on hold till the investigation is completed. So yeah. Next, you are not getting sponsorship from anywhere else. Yeah, you are not getting sponsorship from anywhere else. If by chance I got any sponsorship with the new rules, affect me also. Inviting dependent. So new rules will not affect you. So let's say your sponsor is under investigation. You change the sponsor because you came under the previous rules. This is to the best of my knowledge. The rules have not been published. But since you entered the UK, let me think. So if you change employer, yeah, if you change employer and then you try to bring your dependent, yes, Home Office has clarified that at the point of extension, changing employment, ILR or whatever, the new salary rules will affect you. So the new salary rules may impact you, but you're on a care worker. So that is a different topic to talk about. But being able to bring the dependent, you should be able to bring the dependent. That rule will not affect you because you're already in the UK with that skilled worker leave. Nadia Iqbal, my son will have ILR when. So this is the live question. My son will have ILR when he will be 7. So my question is when he will get British passport. So once you get the British citizenship, so one of the options is you can wait 10 years and on the basis of 10 years residence in the UK, the child can apply for British passport. But once he has indefinite leave to remain, so 1 year from that, he should be able to apply for citizenship to the because it will be even if you apply naturalization rules. After 1 year from getting the ILR, he should be able to apply for British citizenship, provided his application for ILR is successful. And after that, you wait for 1 year and then apply for citizenship. If not, he can wait for completing 10 years and then apply on his own rights. That is a different right, which is independent of ILR. So yeah, 1 year after ILR would be the earlier one. Bulls, I'm on a skilled worker dependent visa for 5 years. Sorry, I'm outside today, so So there may be some issues. Please let me know if the voice is an issue or anything. Uh, I am on a skilled worker dependent visa for 5 years. How will I be eligible for IT apprenticeship in UK? I, so, then I lived over 3 years in the UK. No recourse to public funds excludes apprenticeship. Yeah, if you looked at the guidance of no recourse to public funds, you look at there should be there is a PDF I remember, and there is also in the rules. If you Google search for public funds for the purposes of UKVI or public funds for UK visas and immigration, there should be some information. It's given in detail. The common benefits are listed over there. I don't think apprenticeship is there. So, in my opinion, whatever I have read on that document, you should be fine to do that apprenticeship. I think so, but make sure you tell the college or whoever is handling that. I know there are some training providers who are come in between and they do all that stuff. So let them know what your visa status is and all of that, and make it clear that you don't have access to public funds. Mostly I've seen they do allow people. That's what I've heard from everyone. So you should be fine to do the apprenticeship being on a dependent of a skilled worker visa holder and not having access to public funds. But let the training provider know about your status and that you don't have access to public funds. That is very important. I know, because these training providers may not know the rules exactly, but let them assess, and they if they say yes, then that's fine. That is their decision. If they are doing it, you already come clean and told them whatever your status is. So next question on the channel. Sorry, I have to hold my Mac here. What does this letter mean? EU settlement scheme, family member refusal decision, withdrawal. Yeah, so this is the question on the EU settlement scheme that we have a video on, where appeal was filed for family permit application was filed for a EU settlement scheme, family member, wife to join the husband from Nigeria or somewhere. Yeah, I don't remember exactly the facts, but yeah, so that was filed. Uh, I think the applicant had filed it themselves and they came for the appeal to us. We filed an appeal, giving all the exhaustive grounds of appeal, evidence, etc., proof of relationship and all, and it was overturned by Home Office. So that's the letter that Home Office sends that we talked about on the video. That letter means that Home Office is going to reconsider their decision. Usually, in cases of EU settlement scheme applications, they always reconsider the decision and approve it. So in this case also, they gave it to the person, they asked them to submit their passport and approve the family permit application. So that letter means we are going to relook at the decision and make a new decision. And mostly always, whatever I have seen, they have approved it under the EU settlement scheme applications we have done. So sure, thank you very much. That's fine. Okay, thank you, Bullseye. Yes, so next question on the channel. I'm on a skilled worker visa, currently on a 5 year visa. Recently got sponsorship from the company. I'm unmarried. Skilled worker visa, 5 year visa. I'm unmarried. In a future, if I want to marry and want to get my partner, still the new salary needs apply to me. What depend apply to for dependent? Yeah. So this is another new question that I've got. So someone who is already on a skilled worker visa, and the question is about the rule change that is going to come for dependents not allowed for the care worker visa. So I'm assuming you are on a care worker visa only. So the dependent changes don't apply to other skilled worker areas. That's what I understand from the Home Office fact sheet. So if you are having one of those care worker visa, senior care or care worker job codes, then the dependent will not be impacted because you are already in the UK. The changes will not impact you, number one, and the new salary requirements will not impact you because you are continuing to work for the same sponsor. So the dependent can be joined. My answer is yes, you can get your partner subsequently when you get married. Yeah, so that the answer is yes to that question. Ripa Khan, okay, no live questions. Question from Ripa Khan, 1984. The job I do is on the list of eligible occupation codes, and I get the going rate of the job I am doing. Am I eligible to switch to a skilled worker visa? I do is on the list of eligible. I get the going rate for the job I am doing. Yeah, so the way the going rate works is you just, for the skilled worker visa, the requirements of minimum salaries are much more than the going rate. So if just by getting the going rate, you cannot be sponsored for the skilled worker visa. So currently, at least 26,200 has to be paid. So let's say your job is going rate is 24,000 per year. 26,200 is the going rate for currently. Then you should be paid at least 26,200 for a 37.5-hour working week. That is the current situation. However, if you file after the rule changes on 4th of April, if I'm not wrong, skilled worker to 38,700 minimum salary, 4th of April, it will increase to 38,700 from 26,200, which is the current minimum. Then instead of the going rate of 24,000, you will have to be paid at least 38,700. So that is how the going rate rules apply, whichever is higher. So you cannot just get the skilled worker visa with the going rate. Next question. My friend received defined cost for healthcare worker position on his cost tier and category mentioned as skilled worker new hire. Okay. Now, under which option he has to fill visa application? Can he submit visa application under health and care worker visa as it allows for IHS exemption? Yeah. So the question is, 2 points on the costs are always there. One is whether it's a health and care visa. Number one, that is on the skilled worker application. You'll find this question. So basically, on the cost, the employer has to confirm by the job code itself, they are confirming it's a healthcare visa, number one. And number two is whether it is a new entrant or not. In your position, NAV 196, employer has got a defined cost for a care worker visa job code, and they have take check marked as a new entrant, new hire. So your question is, can he submit a visa application under health and care worker visa? Yes, uh, you can submit the application under health and care visa. Health and care visa holder can also be a new entrant, so they may have done all the calculations for the new entrant and all, as it allows IHS free exemption. So yeah, you don't have to pay IHS for that. So you can select the health and care option because your job code is what matters. The new entrant option does not matter to the application when you are selecting is it a healthcare visa or not. So you have to say yes because your job code is connected to that. If your job code is healthcare job code, the answer should be yes, it is a healthcare visa, and you will not pay IHS when you go forward in the system and when you go to the payments. So yes, you are right. You can apply with the healthcare worker visa option under skilled worker. Okay. Hello. Okay. Some king of kitchen. Hello, sir. Question is, I need to ask one question. I'm already working in the UK. My salary is 26,200 pounds. After April, I will get 38,700 pounds. According to new rule. No, no, no. That is not right. So the question is, this individual, so you are working king of kitchen, maybe you are a chef, I see your picture. So you are getting a salary of 26,200 pounds, and the question that you are asking is, my salary is 26,200 currently. After April 24, after 4th April, that's what it means, I will get 38,700 pounds. No, that is not the case. Home office has made the rules. Your employer and your contracts are different. So home office and those will be at the point when you extend or you go for ILR and all. Because you are on the current rules, employer can keep paying you whatever they are paying as per the previous cost whenever they issued it. They will have to increase when they extend it, or when you change employer, the new employer has to give the new salary, or when you file for ILR, at least at that point, they will have to raise the salary to 38,700. They don't have any obligation to increase it now. So just to clarify, people's salaries will not increase because Home Office has changed the rules. So, okay, next question, Mukesh Raja. Live question, in spouse visa application, for how many times have you visited the UK? Should I mention each entry to the UK because previously I was in student and traveled couple of times and also in tourist? Prefer to mention as much as possible. Try to give to the best of your ability. Look at your passport, e-tickets, whatever is you can find out. Try to give as much as possible. Worst case scenario, if you are unable to find, you can write a covering letter saying how much ever I could find, I filled it up. And yeah, that's one thing that you can put in the additional information or the covering letter saying I was unable to find these 10 absences which I filled up, 10 entries or something. But I don't think that application requires you all of them. If it is requiring you all of them, put them. It is not a field that will lead to any visa refusal, but yeah, what I would say is, if it is not fitting up in those columns, maybe attach a spreadsheet or something giving your entries and exits from the UK and mention it at the top or anywhere in your covering letter that to the best of your ability, I was able to locate these dates. So that's what my suggestion is. try to give as much as possible, uh, as much as you remember. Next question, my course got withdrawn. I got email from university, but I haven't get any email from home office. And my BRP valid 7724. Can I travel in and out of the UK? Okay, so this is quite an interesting question. People are getting their visas cancelled. I've seen that cancellation emails are coming through to students who have not met with whatever compliances of those universities are, attendance fees, etc., etc. So Dinesh's question is, my course got withdrawn, so it's withdrawn from the university. That's the first point. You got email from the university, we are withdrawing you and we are reporting you to home office. Simple as that. That's what they will say. Standard copy and paste email. But I haven't received any email from home office. So the university has reported to home office, but home office has not got to canceling his leave. That is common. I've seen about 2-3 months or so for students. Sometimes for students I've seen up to 3 months or so they do give it, very rarely 6 months, but yeah. So whenever they pick it up, they will cancel the visa. You will get an email saying your leave, let's say you get the leave today 16th of February. If they send an email today, it will count 60 days from today. Your leave is going to end on this particular date. That is how it will end. Your question is, your BRP is valid up to 17 September 2024. Yeah, which is quite long, about 7 more months, yeah, approximately. Can I travel in and out of the UK? No, you cannot travel in and out of the UK. If you try to travel and if the caseworker investigates with your university, like whenever you come to the immigration officer at the port of entry, I'm pretty sure you are a visa national. Yeah, so you have BRP also, so you are a visa national. So when you come, the immigration officer may call the university, ask them, check with them. That's where they will not allow you. As soon as the university says, we've already stopped, he is not attending or whatever, we are no longer sponsoring, they will, the immigration officer will send you back home. That's number one. Even if not that, let's say if you leave the UK today and tomorrow home office sends you the cancellation email, your cancellation is from immediate effect. So from tomorrow only your visa ends. There is no 60 day, there is no entering. That's how the immigration rules are. If you're outside the UK, the 60-day rules does not apply to anyone. If you're outside UK, it's from the date the notice is issued. Your visa is ending. That's the end of it. So these are the two big issues that you will have. I would advise against it, against traveling when you are waiting for a cancellation email from the home office. Okay, what is next? Yeah, I think you already left. So the next question is, you are already in your home. Right now I am in my home country. So you've written subsequent question. Can I switch to tier 2 sponsorship visa? Will be any problem if I file tier 2 visa while my student DRP is still valid? Yeah, so now his question is, I think he's already left. There is another question on another comment. So exactly the same individual. He's gone back to his home country. I am in my home country. Can I switch to tier 2 sponsorship? Yes, you can. You will need a defined certificate of sponsorship. You will need as good as anyone else who is applying. Your student visa, you didn't meet compliances unless you broke any immigration rules. Let's say you worked more than the allowed hours or anything else like that. Then you don't have any issues with the subsequent visas. That's the skilled worker visa you want to apply or the care worker. It will not be an issue if you have not breached any immigration rules. Being withdrawn from university is not that much of an issue unless you have tried to defraud or done something wrong. Anything is they have against you. So if you are unable to pay the fees or you go back, that's quite fine. You can explain it in the covering letter in your subsequent visa applications. Yeah, why you did not continue your studies? You did not like the course, the university has issues, you didn't have money, whatever that is. You can come clean and explain that to the home office. It should be fine. That's what I can say. Mukesh Raja, next question online, live question found online. Some people have attached up Appendix 2 form as part of the spouse visa application. Is it still required? Base BC, read online, it's no longer. Yeah, the Appendix 2 form has gone at least 5-6 years back. At least 6-7 years back. Home Office has gone fully digital now. That form has been incorporated into the application form. So all the questions that you have on the Appendix 2, yeah, I think that was the name of it. It was a PDF you download, you fill it up, and you would submit it along with the application for a spouse visa or partner visa from outside the UK. You don't need to submit that anymore. So Randeep, if travel itinerary changes, sorry, what is the question? If travel itinerary changes, do we need to inform UKVI after reaching UK? Okay, like we put 10 days travel, but we got visa for 6 months. If we stay 2 3 months in this travel 6 months, you need to inform UKVI. Okay, so this is a question, I think on visitor visa rules or something. You tell when you fill up the visa application form on the visitor visa, it asks you how long are you going to stay in the UK. You say 10 days, and then anyways, everyone gets 6 months visa. So if you stay for 2 or 3 months, there are different opinions on this. Uh, if you do this repeatedly, they may consider this at a future. I have seen 1 or 2 refusals where clients had done something and they send it to me, and I saw that where one of the points that they mentioned is, oh, you said 10 days and you stayed 3 months. So that's why I don't believe you have a genuine intention of visiting the UK. So be careful of doing that. But as per the immigration rules, I have not seen it. That's also only an additional reason of refusal. Every time I saw such refusals for staying extra, say you said 10 days I will visit, but you stayed 2 months, whatever that is, example. Uh, in my opinion, from the immigration rules perspective, if that is the only reason you have in your future visa applications, it cannot be refused. That's complete nonsense. But when you make the new visa application, you need to explain why you changed your 10 days to 2 months, whatever that is. Uh, whatever are the reasons, you have to mention in a subsequent visa application that last time I visited the UK from this to this, however in the application I had given this, these were the reasons why I had to stay, instead of 10 days I stayed 2 months. That's what I would say always. That is good practice, but I don't think it's going to be a big thing for future applications. I'm sorry, appreciate. Okay, Mukesh, thank you. Gagandeep, yes, visitor visa. Yeah, so I've answered Gagandeep your question. The instead of 10 days, if you stay 2 months or 3 months, I don't think it's a matter. But if you do that repeatedly, I know it has been used as an extra point in other refusals. People think that this is the only reason for refusal. That is not the point. I know people always argue against me when I'm telling that this is not a big thing for home office. They understand people sometimes have plans of 10 days and it goes up a little bit or whatever that is. But it is always good practice to tell them in advance when you make subsequent visa applications why you stayed extra. Okay, good day, sir. Possible update regarding cost delays. Cost delays, frankly speaking. Okay, so standard applications, yes, I am still getting. I'll just keep this down and answer. Okay, so the live questions. Cost delays, defined costs, undefined costs, they are taking 18 weeks. That is a standard priority service. You may or may not get it. It's 60 slots per day. We do get the priority slots if a visa is expiring or something. Engage a lawyer. But I'm not sure whether you're talking of undefined costs. So if it is defined costs, standard processing is up to 2 weeks. We are getting for most of the roles. I know that all these high risk ones, care worker and all, they are taking 2 months, 3 months. There is no timeline, frankly speaking. And if it's what type of course is it, if you can tell me, then I can narrow down my explanation. What job code is it? Is it a care worker job, chef job, builder job, whatever it is? Then I can try and narrow it down and answer Henry. But generally, yes, all this, yeah, care worker costs, it is going to take time. Home office is investigating almost each and every. In my previous live, I have a document on my desktop computer. I don't have it here now. So where home office is sending all these long questionnaires anytime they ask for. So for example, I'm the care home. I say I want to hire Henry. This is the job. This is what he will be doing. These are the number of hours and all. Even I've spoken to other lawyers, and everyone is experiencing this. Whether you engage a lawyer or not, I've seen they are giving a hard time to everybody. But at least lawyers try to dilute whatever issues they have. But a long questionnaire is coming. They are trying to check what they are doing with the current sponsored workers. For example, if your employer already has 3 workers, let's say, so they are trying to ask their rotas for the last 4 weeks, how they are paid. They are also asking, are you going to recover any immigration health surcharge, any visa fees from the migrant? Is it a part of salary? Yes and no. So this was a big fraud going on. Home Office looked into all these cases, and then they have built up a different questionnaire completely, which goes to all the care homes. As soon as they ask for these decoms and all of that, they are sending. I see that to most of these care homes, and they are asking for all this detailed information for almost 90% of the decost requests from care homes, or even 100%, I would say. So if answers are not satisfactory, They are refusing the costs, they are investigating, so there is no timeline. This is the only the I'm trying to explain what the problem is, what the hold is, because there is a lot of these applications being filed by many employers. Everyone is investigated. These lists go back, then they go and sit in the queue. Even when the information is sent, it sits back, and then when they get to it, they pick it up. So yeah, that is the main reason I cannot advise you exactly what the time is. Even home office has not confirmed. They are taking one case at a time and handling it like that. Mukesh Raja, next question live. For the bank statements, does it have to be certified from the bank, or is it enough if the online statement has all the info such as bank logo details? Yeah, online statements in the as per the immigration rules, if you read and go and see Appendix FM SE specified evidence for spouse visa, fiance visa, whatever that is, you still need physical bank statements. That is what the rules, they have not changed it. But in practice, at least for last 2 3 years, 2 years or more, I know we have been sending online bank statements. They are accepting that. Worst case scenario, if they don't like your bank statement, they will write back to you asking you to provide whatever they want, the original ones. But I have not seen such emails from home office. In the past they used to do that. I've seen that about 2 3 years or more ago maybe. But now they do accept all these online bank statements. But remember, it is always preferable. They don't like the transaction statements. I think they think that it can be modified or something can be done. I don't know what the reason is, but yeah, they don't like those transaction statements. They usually, I'd always advise, give them the bank statement which is downloadable, which is saved on those online banks in the UK. All the banks, any bank you bank with, you will be able to download the statements for the last 2 years. They save it on those online PDFs. So download them. That will have the name and address of the person whose account it is, the account number, and all of that. So that looks like a physical statement. It is like a physical statement. So those ones are perfectly fine. Next question, live, Satish. Hello, tier 2 ICT don't count for ILR. Yes, you are right. Tier 2 ICT don't count for ILR on skilled worker. Okay. Clock to ILR. If switch to skilled tier 2 will be reset. Yes, it will be reset from the point you switch to skilled worker, even if the combination of stay in the country with both visa combined is over 5 years. Yeah, you have to ignore the ICT period completely, because that is not a route to settlement even now. It was never a route to settlement, yeah, since when the changes of April 2011, I think sometime that changed. ICT has not been a route to settlement, tier 2 ICT. So when you switch to skilled worker visa, let's say you switch today you got the approval email from home office that you have got a skilled worker visa from today. From today onwards, you count your 5 years for ILR on the skilled worker visa. That is how it works. Okay, I'll take some questions on the channel. No longer live questions. Where is it? Okay. So minimum salary is written as 2960. Okay. So this is to my, I have made a video, I think 2 days back, 1 or 2 days back. Graduate route visa holders switching to skilled worker visas with new entrant. I'll take the live question. First, let me complete that. So graduate route visa holders can get the new entrant category skilled worker visa, new entrant salary. So in that one, I have given the calculation. So just to clarify, Hafizullah, I know he's asking, the confusion is minimum salary is written in the immigration rules as of today for the new entrant is 2960, but in my video I have said 3960 because I am calculating this 3960 on the basis of the change. My video is after 4th of April. That video numbers are applicable after 4th of April, when the skill on or after 4th of April, when the skilled worker salary will increase to 38,700. So for the new entrant visa for a graduate route holder, if the employer wants to give them a new entrant salary, that video explains that. That's why it is 80% of 38,700. That's how the number will change. Currently in the immigration rules you will see as 2960. You are right. Yes, yeah. Currently it is 2960. That is based on the current rules of minimum salary of 26,200 for skilled worker visas. But as soon as that 26,200 changes to 38,700, the new entrant salary will also change to 3960. So that is a 80% calculation number. So that is the reason I am saying 3960 for new entrant visa from 4th of July 2024 onwards, not now. Okay, that's my clarification, Rizullah. So let me keep this down. Okay, next question. Akhil, if home office, if If the Home Office cancelled your visa by mistake and later revoked it, will this cancel your visa and later revoked it? Will this period 2 weeks have any impact on my ILR when I finish 5 years? Yeah, if they've revoked by mistake, I don't think it happens. I know there are some revocation emails that have gone through. I know I was in a call with Home Office managers where they have confirmed that they had some IT issues and many individuals have been sent these revocation emails for skilled workers. Maybe you are in that lot, but then yeah, if they have done the cancellation by mistake, it is not a cancellation. I know the IT system generated some email and it sent it out to many people. I know, I'm aware of that. It happened sometime back, maybe 6 months or so. Don't remember exactly, but that will not affect you. That is Home Office's mistake, obviously, but you can explain it at the time when you apply for ILR that this had happened and it should not affect you. Maybe engage a lawyer or something if something from your side or from the employer's side had been done. But yeah, if it is on the Home Office's own accord, they did something, then I don't think you should worry about it. It will not affect your ILR. Aditya, I'm finishing my course. Next question on 27th March, as written. As written, so I have a job sponsorship from Big Firm, and they want to start from 5th April after my course completion. Okay, am I eligible for switch because my job starts after the course ended? Yeah, so we're finishing on 27th of March. So the question is, Aditya is finishing his course on 27th of March as per the CAS, or and your job start date you want it 15th of April, which is after the course start date. Your question is, am I eligible to switch? Yes, you are eligible to switch if it is after the course end date. So whatever numbers you have given is correct. You are eligible to switch. Uh, yes, you are right. You can switch because your course end date is 27 March and the job start date is 15th of April. Thanks, Satish Kumar. Any other live questions? Sorry, no live questions. I'm outside now. I'm having so all the questions I have responded. I'm trying to see if there are any more live questions. Any more questions on the channel? No more live questions yet. Yeah, that's it. So there are no more questions. Thank you, Aditya. Thank you very much, everyone, for joining. I will end this live for now. I may do a live again, maybe today or someday. Yeah. So yeah, I'll see to it. Yeah, not sure when the next live will be, but yeah, I'll try and do whenever I can. For now, I will end this live. Thank you very much for joining. And if you do like this channel, do subscribe to it. Write your comments, ask your questions in comments, and I will address all the questions. And what else? Yeah, do subscribe, like, give a thumbs up to this live if once it is saved. Anyone who has already asked the question on the channel, they can watch in their own time. And thank you. Thank you.